Whenever you're in a situation where your company is experiencing shutdowns across their organization in the magnitude that we are seeing today and have experienced over the last couple of months, the associated impact is going to be
Simply Tax.
I'm going to go ahead and interrupt the start of our conversation on business interruption, contingent interruption, civil authority, and related claims and considerations to introduce the guest today and tee up the conversation. Now, business interruption claims are not something that I can claim to be an expert in, but it's something that many I work and talk with are living through right now amid the coronavirus pandemic. I'll be the first person to tell you that I need to call in some help to cut through the static of first-party disputes. So as I often do in these situations, I did just that. On the podcast today, I'm looking forward to sharing with you a conversation I had with two commercial litigators, Weltman and Kevin Dreher of the Chicago office of Reed Smith, and two forensic accountants, BKD's Bryan Callahan and Bob Sprague. As always, you can learn more about and find out how to contact our guest today with the show notes of this episode, available at bkd.com/simplytax. But their simply background is that Will brings to the conversation his perspective as a partner in the global commercial disputes group at Reed Smith, focused on business-to-business disputes and arbitration. Kevin brings 20 years of experience representing commercial policyholders across the world in claims negotiations, disputes, and litigation. Bryan brings to the podcast his experience as a partner and leader in BKD's Forensics and Valuation Services division, and Bob brings over 20 years of experience working with corporate stakeholders, in-house and outside counsel, auditors, and special committees on forensic and fraud investigations. And so, with the combined perspectives of this team of trusted advisors, we'll help you break down the world of business interruption claims with a roadmap of the key issues, considerations for evaluating and making a claim related to COVID-19, the types of documents and information you should be gathering and tracking, the exclusions that might apply, and other important considerations and questions. Let's set the stage by first hearing from Bryan with some insight into the situation and how unusual and out of the normal the current situation and work is for him.
Most of the time when we've been involved, in myself and others within our forensics practice have pretty extensive experience handling and managing the damages aspect of business interruption claims. But it's always been, at least historically, based off of fires, floods, natural disasters. In fact, I had a claim I was assisting with, a first party claim in New York City, of all places, back in January and February, right before we knew the world would get turned on its head. Shortly thereafter, I was assisting in the heart of New York City with an organization that was very hard hit by what happened starting here in March and April. So it's really amazing now to see how quickly things have changed in so many ways. So really great to have the guys on with us here from Reed Smith, because so many of the questions we are hearing from our client base at BKD are questions of coverage. We know enough to be a little bit dangerous, but we definitely like to refer those types of questions to folks just like we have here with Will and Kevin. And that's why I'm really glad they could join us here today. And where we really focus in on is more of the damages pieces of the calculation, and we'll get into what that really looks like. But glad we could all get here and talk about this very important topic, because this is so widespread. There's so few organizations out there that are unaffected by this. So it's a really pertinent topic, and I'm glad we could get together to do this.
The issues are complex and the magnitude is large, so let's start unpacking them with an overview from Kevin. While I would have preferred this to have been an in-person conversation, we kept it virtual to keep ourselves socially distant.
Whenever you're in a situation where your company is experiencing shutdowns across their organization in the magnitude that we are seeing today and have experienced over the last couple of months, the associated impact is going to be a very significant income loss to the company, and an income loss that really is borne out not only by an inability to generate income off of the services, products, whatever it is that you generate and do, but you're also going to have a very significant cost component as well that you're going to continue to incur in order to keep your business afloat during a time when you can't technically operate. And you're also going to have components of costs that you did not incur prior to the event that put all of this in motion. So, and we can talk to Bryan and Bob about that a bit as well, because those are all damage components that Bryan and Bob are very familiar with in the first party context, analyzing and assessing and calculating. So, from the very inception of these types of situations, policyholders need to take stock in the fact that they do have a loss that may be insurable under their first party and time element policies. And the first thing that they should do is to consult professionals in this space who have the experience and the knowledge to deal with these claims. A lot of times, sophisticated corporate policyholders will have a very competent risk management group or risk manager that they can lean on, and they will be the first place to go in conjunction with their internal legal departments and start to assess the availability of potential insurance coverage here. Oftentimes, that's when we will get involved and we will start working with the policyholder to help them create sort of a roadmap or a 10-step plan to start to put in place and assess the potential availability of coverage and to start to prepare their claim. Another companion piece to that will be to work with the policyholder to engage someone like BKD who can come in and work side by side with coverage counsel to help us value and calculate the claim. And one thing in a situation like this, when you have losses that are so significant and are complex and are chock full of very significant coverage questions, is that the policyholder needs to exercise some patience, because these types of claims, given the dollars that are going to be associated with them, are likely to be contested by the insurers, which is going to mean that the policyholder needs to be very concise and deliberate with respect to this claim. Its communications with its broker and its insurance company need to be very concise, and a thorough assessment of the coverage needs to be conducted right at the outset.
And that's a helpful kind of guidepost to kind of know how to approach it. I guess maybe looking at the current situation, are there industries or perhaps particular business segments that maybe are more impacted, would you say, with everything going on, or maybe the claims would be more prevalent?
Every industry has been affected in one way or another. Even those that have been deemed essential and have continued to operate have been impacted. But what I would say is, I put them into two buckets. I take the essential and the non-essential. If you were deemed non-essential, for example, then you basically have been shut down this entire time. Maybe you've had some limited capacity to continue to operate. I mean, restaurants have been very hard hit, even though we know and have all relied on their delivery services, which have been wonderful. We're all thankful they continue to do that, but their capacity has been drastically hit. Any industry such as hospitality, anything tied to travel or tourism, have been completely decimated. The hotel industry has been hit very, very hard as well. So we're seeing a lot of claims and a lot of the early litigation that's been initiated by policyholders against insurance companies have been driven, I would say, by those two industries in particular, hospitality and lodging. The other industries that we're seeing that have been hit pretty hard are the retail sector was hit pretty hard. Yeah, there was online ordering through Amazon and other companies, but with the brick and mortar stores closed and lack of obviously capacity because many plants were shut down across the world, which manufactured these products, their ability to continue to operate was significantly hit. And that's really been on a global scale for a lot of companies. So, we're seeing that across the retail space. And, I'd hate to keep anybody out because everybody has been hit across all industries. But those are the ones that we've seen the most claim activity. And I would say it's still a little bit early to see exactly how this is going to play out for the various industries. and how they bounce back from this. Time's going to tell a little bit as to what type of recovery we see across each of the different industries. But we know that it's going to be very hard for a lot of the restaurants and hotels to recover from this without some assistance.
What would you say in terms of the timeline that might come out to play? Obviously, a lot of this is all uncertain and unprecedented, but what would be kind of a guess there?
Yeah, the timeline is interesting. We're obviously working on a lot of claims for a lot of different policyholders across these different industries. There are a number of lawsuits that have been filed both by our firm on behalf of policyholders, and a lot of other lawyers are out there filing lawsuits as well. We're going to see, I would say, within the first 6 months, some real key issues that are going to be teed up in the currently pending litigation. One of those key issues is going to be the extent to which certain insurance policies require actual physical property damage to trigger a loss under the policy, or whether or not other types of triggering events are sufficient to trigger the policy, such as loss of use of property, uninhabitability of property, for example, or whether or not the presence of the virus in the air on a surface is sufficient to trigger the policy, whether that be constituting physical property damage or otherwise a loss that triggers coverage on the policy. Those are going to be the first threshold issues that are going to be up in front of courts across the country. And I would suspect from a timing perspective, we're looking at 6 months, maybe on a motion to dismiss. If it gets through a motion to dismiss, we may not see rulings on those issues until the summary judgment stage, which could be a year to 2 years out.
Okay, yeah. Well, I know there's a lot of moving parts to that. From the litigation front, I don't know, Will, any insights or perspectives you'd maybe add to that?
Yeah, no, my sense is, similar in line with Kevin. One of the things it'll be the interesting piece will be some courts I think are moving quicker than others under the circumstances, just depending on caseload. So, for example, here in Cook County, because of the volume of cases, especially in law division, and it'll depend on, my sense is also some of these insurance issues end up in the Chancery division here as well, if we're seeking declaratory relief for coverage. But in general, my sense is, we're seeing a lot of delays here because I think the judges are just having, there's just the volume of cases. It's been tough for them to get back on the case. But then there's other counties outside of Cook where, Chicago is, where, for example, in Rockford, where they're proceeding, relatively straightforward. So some of those counties, you might see more action. Similar, I think the same thing is going on nationally. I know obviously New York state courts there have been really slow because obviously it was, the hardest hit and whatnot, but they're even starting to open back up. But, so I think it'll be interesting to see how these matters resolve differently among different jurisdictions. And some of that, will become clearer, obviously, sooner rather than later, depending on when those jurisdictions start to open back up.
Yeah, and Will raises a good point, Damien, that one of the complicating factors on timing here is exactly what Will just said, which is how quickly are courts going to take on new cases, and if and when they do, how quickly are they going to be able to allow litigants to prosecute and litigate those cases? That remains to be seen. Will and I are both handling various pieces of litigation that existed prior to the global pandemic, and they have been moving forward, albeit very slowly. And the question is going to be how quickly can courts get back to business as usual, so to speak, and move these COVID cases through the court system to try to get some sort of resolution one way or another on these key issues that we were just talking about.
Yeah, the backlog, I'm sure, is quite a bit, right, Kevin?
It really is. And Will can attest to this too. Originally, when the pandemic started, I think everybody was caught a little bit flat-footed. I know that I was. I was out of town meeting with a client, getting ready for depositions, when I was basically told I couldn't come back to the office. And ever since then, we've had to push things back and seek extensions. as it started to materialize and become more of a reality, we had to find ways to work around it, such as we're seeing courts using video or Zoom or the like more often to hold hearings. And we've been conducting depositions via video as well. So, certain courts are more open to utilizing technology in the courtroom. Some courts don't really have technology in the courtroom. So it's really going to vary depending on, as Will said earlier, court and jurisdiction that you're in front of. I would say, in a general way, I find federal courts to be more equipped and accustomed to using technology in the courtroom, whereas state courts are really hit or miss, I would say. So, it has, to your point, Damien, it's created a real backlog of those cases that were pending, and now we're finding more of these cases for insurance coverage being filed. And I think as courts open and folks get back to business, we're going to find a lot of people have been sitting on a lot of work by way of litigation that's probably going to be initiated that's related to COVID, but maybe it's not insurance. A lot of contractual disputes and real estate types of disputes, landlord, tenant, all variety of disputes. We're going to find an industry has formed because of this global pandemic in the legal world.
If I can add one more thing, to Kevin's point, with respect to these agreements, one thing I know, I've been counseling some clients on this. If there is, both, there are obviously positives and negatives to this, but if your contract, some dispute resolution provisions in agreements will have both a bifurcated venue provision where you could potentially have an option to invoke arbitration. Others, I've had clients who have explored where they've had disputes and the other party to that dispute has been willing to do so, to agree to arbitration to the extent they want the dispute to be resolved sooner rather than later, because obviously arbitration is a creature of contract, so you can agree to arbitrate a matter, so long as the other side agrees, as assented. One of the restrictions, obviously, because of the pandemic, is if a claim that you're bringing in court potentially requires a jury trial, I don't know that the courts are still wrestling with how to have socially distanced jury trials, and sometimes the only way to settle a case is to get it ready to trial, get it right up to the trial point. So some clients have been willing to and looking to arbitrations. Obviously, the issue with an arbitration is that you most times have one arbitrator deciding your issue. Sometimes, depending on the provision, you can have a 3-person panel, but there are risks. If you're good about selecting the right arbitrator and have proper rules, arbitration can be an effective tool to both deal with the limitations imposed by the pandemic, potentially minimize the cost, although that, again, depends on what rules you're using and how the parties can agree to limit discovery and move a case along. But otherwise, that's one other thing that I've seen in this climate. Clients are thinking about how can they move disputes that they want resolved sooner rather than later to arbitration. Now, how that plays in the insurance context, I'm not sure, because I know obviously it will depend on a lot of time who your arbitrator is.
You bring up a great point there of, you kind of almost have to assess the situation and really figure out kind of what the options are and maybe even the magnitude of it. And so I guess maybe just kind of going through that. So maybe the assessing the magnitude of it, kind of figuring it out. Bob, I know that you get, I know you have a lot of people kind of coming to you right now, especially with questions or, where do I start? This is what we have. Any insights that you would have following along the lines of what Will and Kevin were saying here in terms of what you're seeing and hearing, and then how to kind of maybe start to figure out and assess what a claim might look like?
The questions that we're getting sort of fall into two buckets. The first bucket being, do I have the appropriate coverage to file a claim? And that's where we can provide a little bit of advice to clients, because we've done these types of claim preparations and have been involved in disputes in the past. But again, this is all very new. We haven't seen a pandemic like this that has caused pretty much every industry, as Kevin alluded to be in a position where they're experiencing significant losses and may want to file a claim. We're getting asked those questions, and to the extent that we can answer them, we try to. But otherwise, we're as Kevin mentioned, we're sort of referring them to in-house counsel and coverage counsel to get those questions. Probably the next bucket of questions that we get is, if I think I have a claim, a valid claim, what should I be doing to prepare for that claim? When do I start measuring the claim? What are the types of documents and data that I need to maintain in order to, support that claim? And again, one of the key questions, and one of the I think the key challenges that we'll see from insurance companies now is trying to measure exactly when losses started to occur. Unlike a natural disaster where you can sort of measure when a tornado levels your business and your operation cease as a result of that, with COVID, measuring the date where it started to impact companies is going to be very difficult, and it's going to be very case by case specific, very industry by industry specific, and even location by location specific, because as we all see in the news every day, cases in some states are on the rise, cases in some states are going down, business is returning to normal quicker in some locations than it is in others. You take the restaurant industry, for example, as Kevin alluded to, you had restaurants that were sort of deemed somewhere in between essential and non-essential, but likely they started to experience losses early on when consumers, just didn't want to take the risk of going out to eat at a restaurant. So you may have seen their business start to decline then. States and governments implemented sort of stay-at-home orders, and restaurants were only allowed to provide takeout and delivery services. So, clearly there was a time period where revenue for those businesses going down, and then another sort of triggering point where they could only offer takeout and delivery, and it would have declined again significantly. So the advice that we're sort of giving, and it's similar to sort of a natural disaster claim, is start to build a model, and that model would include, looking at your historical revenue pre-COVID, and then to the extent that you need to sort of break down in as much detail as possible, what your current state looks like sort of post-COVID, so that you can have a supportable model that will, ultimately can be presented to the insurance company to show pre-COVID state and post-COVID state. Again, for certain businesses that may even require disaggregating the data based on different revenue streams. That sort of the more complicated the business operations that you have, the more detailed information you'll want to be including in your model, such that you have, again, a supportable claim that's backed by factual data.
Bryan, from your experience, I know that kind of the managing the data and getting it together, that's obviously a big challenge here. But any perspectives you would add to what Bob was saying there, things to keep in mind, or things that people should be focusing on before even going to a Kevin to talk about some of the language in the contracts or the insurance amounts?
Yeah. And at the same time that insurers are thinking about coverage questions and going to folks like Kevin and saying, hey, Kevin, what do you think about this? They should also be thinking about the damages aspect to it, because if they think they have started to incur losses, the time is now to start actually tracking those. And when it comes, this is the very unique thing about business interruption compared to other types of damages that our forensics team, our litigation services group will manage. And that is the fact when it comes to business interruption, you have to actually look to the policy itself for definitions. Where so many other times, let's say there's a breach of contract, and the breach of contract claim, you generally speaking don't have a lot of definitions defining how a business income loss would should be calculated, right? So that's where many times CPAs like ourselves are hired to come in and understand what's going on with the contract, applying GAAP, so the generally accepted accounting principles, AICPA standards, and our standards as forensic experts, and say, okay, based off what we do, what we believe to be the damages, here's our expert report. What's very unique about business interruption is that you do actually need to look to how the business income loss is defined in the policy itself, because it may not follow GAAP. It might be very different than GAAP, and it is very specific to that policy. So that's where, as an insured, it's really critical that you get out kind of a magnifying lens and really dig into that to understand it. And then, of course, we stand by your side to help you think through that too, because it may not be your traditional kind of GAAP conclusion of what a business income loss would be. So that's a really critical component to make sure you understand that policy and dig into it deeply. And typically, there's really two parts to a damages calculation, the damages portion of a potential loss. And the one I just mentioned, the business income loss, what would have been your income absent whatever event has actually caused the property damage. In this case, we're thinking COVID-19 potentially, right? And then looking to the definition of net income, et cetera, when it comes to business loss. The other thing, though, it's typically a part of these policies as well, is the extra expense clause that's also part of these policies. Effectively, that covers any extra expenses that you have incurred as a policyholder, as an insured, when it comes to whatever the damages are, whenever it comes to the event that has necessitated a potential claim. In this case, we're thinking COVID-19, fire, flood, etc. You can start gathering information about what extra expenses have you incurred. Is it extra supplies that you've had to buy? Have you gone and bought thermometers, right? That's the big thing right now is everybody has to go out and buy extra thermometers so they can actually test their employees or visitors for potential fever, right? That could be an extra supply. I'm thinking about restaurants or hotels, and the plexiglass are all having to, one, purchase, and then two, install and do so. I'm sure that whoever is selling those are probably not doing so at a discount right now, right? And this is their glory day in terms of selling and installing plexiglass dividers. And you're probably going to have to pay a premium for that right now. So that would be an extra expense. And the list goes on and on. It will be unique to your location, unique to your industry, your particular organization. So anything like that can be potentially part of an extra expense claim. So what we recommend, if it's possible within your accounting system, we think it's best practice to set up a separate general ledger code, what we just call a GL code, GL account, or accounts, right? Maybe it's multiple things you want to track separately for these extra expenses and do it right away. And it doesn't even matter necessarily if you end up not filing a claim, because you can just take that account and actually reclass it as something else later. But if you think there's a possibility you're going to need to file a claim or you're going to file a notice of a claim, we highly recommend setting up general ledger accounts in your accounting system and just start putting things into it just like you would other expenses. Keep all your receipts, keep all your invoices, because you're going to have the documentation supporting it as well. So that's kind of the best practice that we see is gathering up all the documentation, setting up those GL codes so you can actually track the extra expenses. And from the business loss income side, you've got to take a look at the policy itself and then start going into, okay, what does that mean? How do we apply it?
Figuring out what you got to account and how to track it. So I don't know, maybe Kevin and Bryan was just saying this, right? That it's specific language you have to be looking for and figuring out if you can make a claim and what would work. So could you talk a little bit about that and some of the things to think about, maybe the triggering events and that specific language, even with shelter in place orders or stay at home orders that could come into play here?
Building on what Bryan just said about tracking the loss, one of the things that's going to be really interesting here in these particular claims is how the loss falls into different, what I'll call coverage buckets within the policy. These policies have various types of coverage, and usually what you'll find is that there are going to be limits or sublimits associated with each type of coverage that's going to be triggered here. And these events surrounding the losses arising from COVID are certainly going to be triggering multiple buckets. And so to Bryan and Bob's point, it's going to be important for policyholders to keep track of those costs and those loss numbers as they move forward, as they're incurred. So, for example, one bucket of coverage is going to be civil authority. Civil authority, as you alluded to, Damien, is going to arise from the various shutdown orders, shelter in place, orders related to inability of groups to gather, and the like, all of which has had the direct and indirect effect of shutting down in whole or in part various businesses. The ultimate effect being that losses were incurred, and as Bryan alluded to, extra expenses have been incurred as well. Those civil authority coverages are going to have specific language tied to them, both as to triggering events. For example, a lot of the language around civil authority coverage may have a waiting period. It may be that the order of civil authority has to be in effect for 24 hours or 48 hours before civil authority coverage is triggered. And then typically there is going to be a window of time during which your civil authority related loss can be incurred. For example, 45 days from the date of the order of civil authority. And your loss, as Bryan knows, will be calculated based on that. One of the interesting coverage issues that's going to come up is whether or not each act of civil authority here can constitute a separate loss. So, for example, as we know, shelter-in-place orders were put into effect. They were put into effect for, say, 3 weeks. And at some point, the civil authority orders were changed, amended, altered, and a new civil authority order was put into effect for another month. So one of the questions ultimately will be whether or not there's a compounding or a separate claim that can arise out of each act of civil authority. All of these issues are going to be driven by the language in each specific policy. I suppose we should just keep saying that over and over. Every policy in this space is going to be a little bit different. Liberty Mutual has its own form, AIG has its own form, and they all are a little bit unique. So, with respect to your question, Damien, about language in orders of civil authority that may or may not be more helpful than others, in my position, first and foremost, is going to be that any act of civil authority, regardless of the language that's in it, that shuts down a business due to a pandemic of the nature that we're experiencing, is going to be a triggering event under first party policies as a general matter. Now, I have to say that. But is there language that may or may not be more helpful? Sure. And certainly it's going to be more helpful if there is a direct reference to property damage being a specific reason why an act of civil authority or shutdown order has been put in place. And some of those orders that are out there do in fact say that. Some of them don't. Some of them allude to it. But I would say that in every one of them, whether it says it or doesn't say it explicitly, it certainly is implied, and it certainly is a reason why, not only for the health and safety of individuals, but also to guard against the effects of the virus on property, whether that's real property, personal property, or otherwise. There's a reason why we all wash our hands so much, not only because we touch other people, but because we touch lots of things. And those things can be damaged by having the virus on them. There is going to be litigation around that issue as to property damages. That's just one of the issues out there on civil authority. Other types of coverage buckets are going to be business interruption coverage, which typically is going to be triggered by a loss or damage to the insured's actual property that results in a loss of income. And there's going to be a separate limit for that in the policy. Usually that's going to be one of your larger limits. Another type of coverage or bucket of coverage that's going to be crucial here is going to be your contingent business interruption coverage, which essentially is what we think of as supply chain coverage, particularly given this loss. You have a lot of shutdowns of suppliers and customers that affect policyholders. If you think about, for example, a company that manufactures a certain widget, let's call it a hair dryer. That company is going to rely on its suppliers to provide them with supplies. And this pandemic has affected supply side and customer side. And in the contingent business interruption world, depending on the language of your policy, if you have a shutdown to a supplier that has a negative impact on your ability to operate your business and generate income, that is a triggering event that is going to allow you to access your contingent business interruption coverage. So those are the main types of coverages, in addition to, as Bryan said, extra expense and also expediting expenses, which you can think of expediting expenses as if you need certain supplies and in order to get them, you have to pay additional freight in order to have them shipped to you. or if the cost of acquiring the goods, has gone up, that's going to be another type of expense. Those, I think, and I think that's a lot of information in response to your question, Damien, but hopefully that helps.
It definitely does, yeah, because it's tough to navigate here, and maybe kind of a follow along that I'm sure has a lot of layers to it as well. Maybe again, repeating what's your phrase here, that it all depends on the contract, all depends on the insured, right?
Correct.
Or the company. I know there's a number of exclusions that kind of come into play here. Could you talk about some of those? Because again, on the front end, there's a lot of heavy lifting and figuring out that has to happen. Knowing if there's an exclusion that applies early in the process would, I imagine, be pretty helpful in terms of saving time and energy to know, although it may be at the same time be very disappointing. So any perspectives you could offer on that?
Absolutely. That's the other big fight that is going to occur here in the litigation context, is going to be the scope and application of a variety of different exclusions in first party policies. Again, the devil's in the details. Every policy is going to be different. The language around these exclusions is going to be different. I've looked at probably 50 to 100 policies over the last couple of months, and unless I'm looking at a policy issued by the same company I just reviewed, it's going to be different. And even the same company may have versions of a policy exclusion. So, for example, there are exclusions that we're hearing the insurance industry just refer to as virus exclusion. What's being referred to as virus exclusions come in a lot of different packages. They mean different things because the words matter. A comma here or a comma there, or an and versus an or, grammar matters. And in the virus exclusion world, that's the exact same. We're seeing exclusions that, for example, are packaged in the nature of pollution exclusions in first party policies. And in some instances, pollution includes a virus or may not include a virus. Same with contamination exclusions. We see some of those in these policies. And in a similar vein, they may or may not include a virus. And the way in which they include or don't include a virus is going to matter. Without giving any more specific details, let me also add that exclusions can have different breadth and scope. And again, it's the language that dictates the extent to which they're going to apply to a particular claim, to a particular type of coverage under a policy. For example, there's lead-in language to exclusions that in the law have a variety of different effects. There's what's called anti-concurrent causation language. For you lawyers out there, maybe you know what it is. For laymen, let me explain. Anti-concurrent causation language was developed in the insurance industry, the intent of which, at least, was that insurers were tired of policyholders finding ways around exclusions, to put it mildly. And so the insurance industry got together and they devised language that they felt was the broadest possible exclusionary language that excludes any losses arising directly or indirectly caused by, resulting from, or that type of language. Lots of words. What essentially the industry propagated that it meant was that any loss in any way involving this type of an event, here a virus, is excluded. That's called anti-concurrent causation language. If your policy has that type of language, then the insurers are going to tell you that you're never getting around that exclusion because it's super, super broad. That's fine, and that may or may not be true. As a policyholder lawyer, I would need to look at the details. I would also need to look at the state law that's going to apply, and in certain states, anti-concurrent language is not going to apply. So that is just an example of the breadth of these exclusions and how they may or may not be applicable to your loss. A lot of these policies with these exclusions don't contain that type of language. They are much more narrow in scope, and they may only apply to a certain type of loss, such as they may apply to a business interruption loss, but not a loss occasioned by civil authority. So the devil's in the details. But Damien, you're right to point to this issue because this is going to be a huge issue that is going to be litigated for years and years. And that is the extent to which these policies contain exclusions that preclude the insured from recovering anything on their loss. And they're going to be very interesting.
Hey, Kevin, that actually brings up a really interesting question, I think, that I've been reading about lately when it comes to the litigation aspect of this, especially focused on the exclusions. So I was reading recently about a judge coming to a decision in, I think it was in Pennsylvania, and just wrote a scorching opinion, basically saying no way would a virus, a pandemic, be covered based off the policy language. This is exactly why the exclusion is there. It's plain as day. It might have even been on summary judgment. I'm not sure, but the judge was very very clear. Like, this is, you're out to lunch. This is so far gone. And then I just read another court decision, and I forget which jurisdiction it was. They said, "Oh no, this makes sense. Absolutely, there'd be coverage here. Finding on behalf of the insured or the plaintiff in this case. Yep, no problem." And I can't remember the jurisdictions here, but I think we're going to keep finding this across the country, right? And some jurisdictions yes, some jurisdictions no. It's going to depend on all the devils and the details that you just alluded to. So my question is, if a policyholder who's paying attention and they're kind of saying like, well, my insurer is telling me there's not going to be coverage, and they pointed to this case that was just decided in my jurisdiction that denying coverage, and that's just a slam dunk for them. Should they still consider filing a claim or not if it's in their jurisdiction, when they're otherwise maybe seeing elsewhere that they're having more favorable opinions for the policyholder? So what do you think about that?
That's a great question, and breaking that down would take a long time. Let me try to answer your last question first, which is to say the devil is in the details for a variety of reasons. But putting those details to the side for a second and just addressing your question on what should the policyholder's mindset be with respect to whether or not to submit a claim for losses under the first party policy. My general advice is that you can't be harmed generally by putting in a claim for coverage if you have reason to believe that you may have coverage for that claim. And reason to believe can mean that you've occasioned a loss that you believe was caused by what you think to have been a potentially covered event. Even if you have a situation where you're in a state where maybe there's some negative case law against you, it is unclear whether or not in the long run that case law is going to be dispositive of your claim specifically, for the exact reason that we've all been talking about, that the policy language could vary, the law could change, the legislature in that state could come out with some sort of an act that alters the availability of coverage under your policy. We've seen that in Louisiana and in some other states like Indiana has some issues around the scope of the pollution exclusions that may be in effect. So you can always withdraw your claim. But what you can't do is you can't file a claim after your claim deadline has passed. So you want to be very careful of timing as it relates to when you should file a claim. Typically, under your first party policies, there are going to be requirements for the policyholder to file their claim within a particular period of time. Otherwise, they could run afoul of late filing or late notice requirements that could, in a draconian way, preclude them from pursuing their claim in the first instance. But to answer your question, just sort of directly, you can file the claim. You can always change your mind later and withdraw the claim if you think that for one reason or another you don't have coverage, or it's too costly to pursue it, or whatever your reason may be. But my advice generally, without knowing anything more, would to policyholders would be go ahead and file the claim. It's going to take you some time to perform your investigation, and if upon your investigation you determine otherwise, you can always take a different course.
Yeah, thanks, Kevin. I think that's sage advice and makes a whole lot of sense since there's so many different variables at play here. Thanks for that.
Kevin, I actually have a question that's a slightly different topic, and I'm actually interested in anybody's thoughts here. When we measure damages on a business interruption claim, it's done over the restoration period. So the period from when the triggering event occurred to when sort of normal operations resume, which isn't always black and white in other types of business interruption claims. But for these, I think it's going to be very difficult. I mean, if I think about industries like airlines, hospitality, restaurants and bars, it's totally driven by sort of consumers' fears of actually sort of resuming normal life. And personally, I think industries like that are going to be impacted much longer than anyone can really measure, and it's going to be hard to sort of figure out what that restoration period is. So I'm just curious what your thoughts are. When we get into calculating damages on these types of claims, how are insurers going to view, for example, a claim from a restaurant that said things sort of have gone back to normal, but my business is still way down because nobody's coming to my restaurant because they're scared of that next wave.
Yeah, that's a great question, and again, and this is not an out, but I think we're going to see a lot of litigation over the period of restoration here. I mean, look, there's a lot of moving parts. It may depend on the policyholder and the policyholder's business, and it may depend also in part on what type of coverage we're looking at. So, for example, I have policyholder clients who operate global businesses, and they have operations in China, for example, in Southeast Asia and elsewhere. So the impact of this global pandemic by companies like that started when we saw a global impacts on companies' ability to operate, even when the direct effect here in the US had not yet been felt. I think in those events, you have to take a holistic view on when does your period of restoration begin, when is your trigger, when is your date of loss, and think about it that way. And that's going to require, as you know, Bob and Bryan, it's complicated, put it that way. There's going to be a pretty thorough investigation that would need to be conducted to see when those impacts began. And then you'll have situations like you just mentioned, which may be more localized in a geographic community like a restaurant. Assume you're not a chain and you're just located in one geographic area, then your footprint as to the effect of the virus is going to be a little more confined in time and space, and it may be easier to identify when it began in that particular locale. Now, look, I mean, the interesting thing, one of the interesting things, a lot of interesting things about this situation as to when it began is that I think we've all come to learn that the virus was here in the US long before it was announced that it was here. I think that New York overnight didn't just all of a sudden have widespread virus. It was there for some period of time, and therefore it had been traveling throughout the cities in particular before the pandemic was officially announced, meaning it was here before the closures started. So the question is going to be, were there impacts, to your point, prior to acts of civil authority that might otherwise trigger coverage? That we may not know right now, but if we look at a restaurant that closed on March 16th and could only operate partially through curbside or delivery service, we can a little bit more easily in that sense identify a starting point and look at your actual income and revenue during the affected period of time and compare that to the income experience maybe the year prior or 2 years prior, and have something to compare it to measure what your delta is and come up with your loss. Now, you guys do this all the time. And how far out that loss is going to go and what your period of restoration is going to be dependent in part on what is called for in the language of the policy, which many of them will say it's, your loss is going to continue, until a point when you essentially are made whole, i.e., you can continue your operations in the normal course, as if the loss hadn't occurred. It may be that is an extended period of time, but a lot of times, as you guys know, there's going to be dates specific that your loss can only continue for a certain period of time, and then maybe you have an extended period of indemnity in your policy that you can tack onto that. But insurers are eventually going to draw the line in the sand, and they're going to say, okay, you can only take your loss out to this particular period of time, and we're not going to extend it any further. And we've seen that same thing, for example, in hurricane claims, where the hurricanes are just completely wipe out an area, and it takes months and months and months to be restored. We see insurers kind of draw that line in the sand and say, here's where your period of restoration ends. So it is going to be a very interesting issue, and it's in part going to be driven by the language and the policies, but also how it is that the country and the economy restarts. Do people get over this quickly? Do we come to a point where we have a vaccine, for example, and people can not suffer from the fear and can re-engage in life in the same way that they did before? All of that is going to impact that period of restoration.
Great question, Bob, because a lot to think about. And, maybe once we get past the hurdles of that we've been talking about, what is the period and figuring out the claim, all of these different pieces, let's maybe get to the other side of it's been successful when we start getting the proceeds. And I don't know, maybe Will, this is an area that with some of your background, maybe you've seen what are maybe some claims that others can make against those proceeds, perhaps, or uses or limitations on the proceeds.
In particular, given certain of the industries that the pandemic has impacted greater, those industries have some unique issues. In particular, hospitality and restaurants. For example, with the hospitality industry, if you're a hotel owner and you have a management agreement with either one of the brands or another management company, and you as the owner make a claim for business interruption for the lost revenue, and you get paid out on that claim. Now, you have to look at your agreement, and because most of those, the hotel management agreements provide for a certain, regular management fee, and then usually can provide for an incentive fee in certain cases. They also usually have provisions as to how insurance proceeds should be used. In particular, this comes into play a lot of the time involving hurricanes with hotels, and that what is an owner of a hotel, especially when a hotel has been either completely destroyed or partially destroyed, what do they have to do with that hotel? What do they have to do with those proceeds? Do they have to rebuild? If they choose not to rebuild, what are their obligations with respect to any proceeds they received to the management company? Now, here in the COVID related issues, you're likely not going to have an issue where the owner of a hotel chooses not to rebuild, but you could have a situation where an owner chooses not to reopen, as you all were just discussing, based on the impact of travel, the profitability of that asset, other uses you could use for that hotel asset. I mean, depending on how large of a hotel, can it be repurposed? Other sorts of things like that. And really the devil will be, as Kevin has said with the policies, similarly here, the devil will be in the details of your agreement as to what, the owner of a hotel would have to do with respect to any business interruption proceeds. Similarly, if you're the management company, or if, in the restaurant space, franchisee, or just an investor in a restaurant, and there are proceeds received, what is your entitlement to any of the proceeds received based on, whatever your partnership agreement says, any relevant agreement. So what, we're advising and counseling clients now, but also just in general, is look over your contracts. Usually there'll be an insurance provision, whether your company's an additional insured on the policies, that can obviously make a claim for those insurance monies easier. And you may actually have, even though you don't have an insurance policy, this is something, Kevin can speak to in greater detail, but you may have a right to make an independent claim, your business, even if you never procured insurance, but because if you were named as an additional insured on someone else's policy, you could potentially have similar rights that you may not know you have in some of your agreements. So what we're, telling people and advising our clients to do is, look at your agreements. If you have questions, we'll help wade through those as to what your claims and start game planning for what are the next steps once the economy and once business start to get up and running, and what are ways to mitigate the losses that you've incurred as a result of the pandemic and, the impacts to your business during these times.
What if a company took advantage of some of these relief measures and received some funds there? I mean, is there a clawback maybe the government would have? And maybe even more broadly, looking at kind of maybe future legislation at this point in time is what it would be, but, some sort of a mandate to insurance companies on paying interruption claims?
Yeah, on that last point, Damien, we've been watching state legislatures. We've seen some activity with respect to certain states taking or at least contemplating legislation that would enable policyholders to access their first party policy for proceeds here. It remains to be seen to what extent that type of legislation is going to be passed. Like I said, the candidates who have been pushing that the hardest, we've seen in Louisiana, that type of legislation. New Jersey, it's been proposed. Indiana, with respect to application of certain of the exclusions we talked about. So there are things out there. And what I would say is that to the extent there is any type of legislation that would broaden coverage under the policies, what you want to look for in your policy is a liberalization provision. Liberalization provisions in policy, it's a contractual provision that allows the policyholder to essentially take advantage of any acts applicable legislatures that would broaden the coverage. So it's a contractual agreement that the parties are going to look to those acts of legislatures as a guidepost to affect the scope of the coverage. Obviously, the insurance companies are not going to allow that to happen without a fight. And in terms of the proceeds, I mean, typically under an insurance policy, if you recover, you can use those proceeds as you see fit to help your business recover from its loss. And the other part of your question, Damien, was what if you have a recovery from another source, whether it be from some federal relief package or otherwise? I mean, typically you're only entitled to recover for your loss, and your loss is going to be calculated in a way that typically would account for a recovery from other sources. I'll footnote that, again, I think I mentioned this before, insurance is a creature of state law, so certainly there's going to be a need to take a look at whether or not there is any law that governs your claim that is going to direct you one way or another as to whether or not you have to account for recoveries from third-party sources. I won't get into too much legalese here, but there are concepts such as the made whole doctrine, which requires you to be made whole entirely before an insurance company gets the benefit of any third-party recovery. But we could do a whole nother program on that. So I would just say that looking at the guiding state law on that issue would be beneficial for the policyholder.
Like you said, devil's in the details, right? Got to read those contracts and understand kind of what's at stake here. Yeah, I don't know. And maybe I'll kind of pose this out to the group here. Any other kind of areas related to kind of what we've been talking about, where you think key things based on questions you've been getting or you've been hearing, you kind of want to add? Maybe we'll go around the room here, the virtual room, right? Will, start maybe with you if there's anything from your perspective.
One other area, similar sort of to my last point or along the same lines is, now apart from looking at your insurance policies, especially if your businesses, as most businesses, as we discussed, have been impacted in some way, especially those with some sort of supply chain impact, and anyone who's everyone's seen a drop in revenue. If there are, what you should be doing right now, apart from looking at if you're making a business interruption claim, what proceeds, what you can do with those proceeds, or if you're entitled to someone else's, proceeds from another BI claim under your agreements with that party. You should also be just looking at your, supplier agreements, your contracts, what are your vendor agreements, and starting to see, because a lot of other businesses are impacted along these lines, and depending on the industry, what industry you're in, as we start to get through this and after we get through this, there's going to be a lot of disputes. And what you want to do is, be thinking proactively about which of your relationships, first of all, are most important to you, which also are at most, of those, the most important ones that have a potential risk of a dispute because of some sort of something that happened related to the pandemic, and pay careful attention to the provisions of those agreements and seeing if there's especially a way to, either if it's a relationship you want to preserve following the pandemic, figure out what means you can do under the contract to make sure that that's insured, and also through just business means. But also if it's a relationship that you think is not going to exist, figuring out ways to at least recoup any losses that might be caused by a breach or other actions that happened during the pandemic, apart from making an insurance claim.
Great points. I don't know, Kevin, anything you'd maybe add on to or compliment there?
Sure. Yeah, I think Will hit the nail on the head. I think looking at your contracts outside of your insurance contracts to see if there are any ways of recovery based on failure to perform of the other counterparty. The other thing, I know we're focused on first party business interruption types of coverages. Just want to flag that we don't know how this is all going to unfold as we move forward. Certainly, lots of companies have sustained a lot of losses, and there are going to be, as I said, we're going to have this interesting legal industry that sort of grows out of COVID-19 and claims that maybe we're not really seeing yet or anticipating. And it may trigger other types of insurance coverage. We may see claims against companies, and I certainly hope I'm not planting any seeds here, but whether it be by shareholders or the like, owners, members of companies who are not happy with the way that companies have handled or prepared or responded to this situation, and they may try to argue that it has affected them financially. So we may see avenues of coverage and claims for directors and officers, or professional negligence types of claims, errors and omissions. Those types of coverages may come into play. We may also see suits against companies who failed to protect or failed to warn, whether it's customers or the like. If you think about restaurants, if there are customers who claim or hospitals who claim they contracted the virus by being on their property, you may see lawsuits against those business owners. So I would just say, be mindful as we move forward in this environment, as other allegations and claims and suits are filed as to other types of coverages beyond what we've been talking about here today.
A lot to think about for sure. Bryan, from your perspective, anything maybe kind of, bringing things kind of full circle here, or things to think about?
Yeah, from a damages kind of perspective, as I mentioned, and just to kind of re-summarize on that, just the time to start tracking is now. Doesn't cost you much, maybe a little bit of extra time in terms of starting to just track those expenses and start thinking about a potential loss if you in fact think there could be one. The time to track is now, and not a year from now or 2 years from now. As all of this starts to get worked through the system, it's much easier to do it concurrently in real time than trying to recreate some of the things that are happening right now 2 years from now. So just I'd encourage folks that are thinking about it, put those things I mentioned earlier kind of in motion. And really just also, I want to thank Kevin and Will for their time here today, because as was clearly evident, I think, through this podcast, there is so much ambiguity here. There are so many details to consider. There's so much going on that bringing in teams, attorneys that know this area, and on Will's side, they can help you think through the contracts as well. In addition to what Kevin's working on with the insurance policies, it's so valuable. So I really appreciate their time, their insight. I've learned some things here today, so thank you guys for joining us. Definitely appreciate it.
I will echo that. And Bob, maybe final thoughts on your end before we wrap things up here?
From my perspective, I mean, there's just so many interesting questions right now on this topic. Layering a little bit onto what Bryan said, I think what's going to be really important, there's always judgment in filing these claims. I just personally think that there's a lot more judgment into filing claims related to COVID-19, because there's just so much we don't really know about it now. So to the extent that companies feel like they have a valid claim, tracking it is so important, and gathering the right accounting records now to support that claim when it gets submitted is very important.
I'd like to once again thank Will, Kevin, Bryan, and Bob for getting us up to speed and offering what I thought were some great tips on business interruption claims. With this week's episode, we also interrupted our series of looking back and looking forward on the podcast that we kicked off in episode 100. We'll be back in your feed soon with another key issue and challenge that we're all facing right now. In the meantime, I would really enjoy hearing from you, and it would be great if you would let us know what you think of the podcast by dropping us an email at simplytax@bkd.com, leaving us a rating and review on Apple Podcasts, or connecting with me on social media. You can find me out on Twitter, where I tweet about tax at Damien Martin CPA, on Instagram, where I post about my life at the intersection of tax and being a dad at TaxDad, on YouTube by subscribing to our Simply Tax YouTube channel, and out on LinkedIn. I'm Damien Martin, and thank you for listening.
The information contained in this episode of Simply Tax is based on data available as of the date of its release. BKD is under no obligation to update this information if changes occur. Applying this information to your specific situation requires careful consideration of all facts and circumstances. Any information provided is not to be considered as tax, legal, or financial advice. Please consult your tax advisor before acting on any matters covered.